Here in Canada, there are these two terms that get used a lot: Aboriginal law and Indigenous law. They sound really similar, but they represent two completely different worlds of justice. And figuring out the difference isn't just for lawyers. It's literally the key to understanding the entire conversation around rights, justice, and reconciliation in this country today. So, what is the actual difference? And look, getting this right, it's not just semantics. It's the first and honestly the most crucial step to really grasping the relationship between Indigenous peoples and the Canadian state. So, okay, let's dive right in. All right, let's just break it down to its core. On one hand, you've got Aboriginal law. This is the law made by the Canadian state, its courts, its governments about Indigenous peoples. It's an external system looking in. But on the other hand, you have Indigenous law, and these are the legal orders, customs, and traditions that come from within Indigenous societies themselves. They existed long, long before Canada was even a country. Okay, here's a really simple, but honestly powerful way to think about it. Imagine Aboriginal law is like a biography. It's a story written about someone by an outside author. But Indigenous law, that's the autobiography. It's the story told by the people themselves, in their own voice, from their own lived experience. All right, let's dig into that biography first. We're talking about Aboriginal law. This is the system that most Canadians are at least a little familiar with, even if they don't realize it's only one side of the story. So, what is it really? Well, Aboriginal law is basically a part of Canadian law. You'll find it in historical documents, in the Constitution, in things like the Indian Act, and in modern court rulings. Its whole purpose is to define and manage the relationship between the Crown, that is, the Canadian state, and Indigenous peoples, all from the state's point of view. And you can trace how this law developed through a few key moments. A huge one was the Royal Proclamation of 1763, which set up the whole treaty-making process. Then, over a century later, in 1867, Canada's new constitution handed the federal government massive exclusive power over Indians and lands reserved for the Indians. Then, fast forward to 1982, and this is a big one. Section 35 of the Constitution was created, which for the very first time formally recognized and affirmed Aboriginal and treaty rights. That one section has been the battleground for most modern Aboriginal law cases. So, what did that actually mean on the ground? Well, if you look at the historic treaties, a huge piece of Aboriginal law, you see these specific terms that still have a massive impact today. We're talking about setting aside land as reserves, promising small annual payments, guaranteeing hunting and fishing rights, and providing for schools. These weren't just abstract ideas. These were the real, tangible results of a legal relationship defined almost entirely by one side. Okay, so that's the biography. Now, let's flip the script and talk about the autobiography, the ancient legal systems that are so often invisible to the Canadian legal system. What exactly is Indigenous law? And this quote from legal scholar John Burroughs, wow, it just shatters this old myth of a lawless land before Europeans showed up. The reality was a complex web of treaties, trade agreements, and diplomacy between nations. It was, as he says, a vibrant legal pluralism. So when we talk about Indigenous law, we're talking about these complete living legal systems. These aren't just a few customs, they are fully formed systems for managing relationships, for stewarding lands and waters, and for resolving conflicts peacefully. They are the laws of the people, from the people, developed over thousands of years right here on this land. And right away, you can see just how different the sources of this law are. We're not talking about dusty law books or stuffy courtrooms. Indigenous law is drawn from creation stories, from traditions, from a sacred relationship with the land. The point is, law isn't just something written down. It can be a living thing, woven into the very fabric of a culture. Okay, so we have these two legal worlds, the biography and the autobiography. What happens when they crash into each other? Well, one of the most critical and, frankly, tragic intersections happens in the Canadian criminal justice system, and it's best seen through something called the Gladue principle. And make no mistake, the stakes here are incredibly high. Just look at this number. In 2021-2022, Indigenous women made up 51%, over half of all women admitted into federal custody. I mean, let that sink in. That's not a statistic. That is a crisis. Let's put that into perspective, because the scale of this is just staggering. Indigenous adults are about 5% of the total population in Canada, yet they account for 33%, a full third of people in federal custody. It's this deep, systemic problem that a legal idea called the Gladue principle was designed to start addressing. So, what is the Gladue principle? Well, it comes out of this huge Supreme Court case back in 1999. And here's the key thing. It legally forces judges, when sentencing an Indigenous person, to stop and consider the unique background factors, the history, the systemic issues that might have played a role in bringing that person before the court. And these Gladue factors, as they're called, are really just the court acknowledging history. We're talking about the real-world impact of things like colonialism, the trauma of residential schools that passes down through generations, systemic racism, displacement, all of it. In a way, it's Aboriginal law trying just a little to see the world through the lens that Indigenous law has always understood. Look, getting this difference isn't just a legal trivia question. It's everything when we talk about the path forward. It is at the absolute heart of what reconciliation is supposed to be about. And you don't have to take my word for it. The Truth and Reconciliation Commission couldn't have been clearer about this. They said that true reconciliation is basically impossible until Indigenous legal traditions, Indigenous law, are embraced as an essential part of the process. It's not enough for Canadian law to make a few accommodations. It has to actually make space. And you know what? There's been some real momentum lately. You can see it building, step by step. It really took off with the TRC's calls to action in 2015, which specifically called for Indigenous justice systems. Then Canada adopted the UN Declaration on the Rights of Indigenous Peoples, or UNDRP. By 2021, that became actual Canadian law. And just recently, in 2024, the Supreme Court used that very declaration to affirm that Indigenous peoples have jurisdiction over their own child welfare. Each step is building on the last. And this UN declaration, UNDRIP, it's a game changer. It's not just symbolic. It clearly states the right to self-determination, the right to maintain their own distinct legal institutions, and the right to develop their own legal traditions. It provides a massive legal foundation, both internationally and now here at home, for the revitalization of Indigenous law. So, let's bring it all home. Why does this matter so much? Because recognizing Indigenous law as law isn't a small tweak. It's about changing the entire relationship. It's moving away from a colonial dynamic, where the Canadian state makes laws about Indigenous peoples, and moving towards a relationship built on nation-to-nation respect. It means finally putting down the biography and recognizing the power and truth of the autobiography. And all of this leaves us with what might be the defining question for Canada's future. It's more than a legal puzzle, it's a challenge for our entire society. How can these two legal systems, one ancient, born of this land, and the other colonial, brought from across the sea, how can they truly coexist to create justice for everyone? Answering that question, well, that's the work of reconciliation.